Hi guys, it's Kathy. I hope you're doing well. So I got a special stream tonight. I don't know how I got so lucky, but there are people who are around us every day. And, you know, miracle workers, angels, heroes, none of those words are good enough for these people. All they do is try to make people better every day. That's all they do. And the people they try to make better aren't always nice. And they work long hours and they deal with idiot doctors. And, crappy coworkers. And they do it with a smile. And then they go get you some more ice chips and another warm blanket. And even though you didn't do what they told you to do, and that's why you're with them, they're still all they do is take care of you. I don't know how I got so lucky, but a lot of my vibers are nurses. Not just nurses, any type of caregiver, even mental health care, nurses, doctors. We have a lot of vibers who spend the day trying to make people better in some way, physically, mentally. So I'm searching through videos, to find content, and I see this nurse on stand, and at first I thought she was the one in trouble, and I thought, oh man, I gotta get this video. I gotta get this video. It took me all week. This trial went on all week, and oh, you know what? Before I move on to the video, I do want to mention one more thing about nurses. I had the honor of serving a nurse the other day, but you could tell she was tired. First thing I know when I know they're a nurse, I ask them the same questions. So how many hours did you work today? And it's always the same thing. 12 hours, 15 hours, 9 hours. It's never, oh, 8 hours. I got off, started at 9, got off at 5. It's all good. Never, never. So I'm like, where do you work? She works for the VA. So I had the honor of serving a nurse who takes care of our veterans. And oh man, that was amazing. Nurses are amazing, and there's so many stories they have. Um, I'm not going to point out the nurses that are vibers because you don't know how bad I would feel if I missed someone. You have no idea how crushing that guilt would be. So, if you're a nurse and a viber, when this video is over, go into the comments and say, I'm a nurse. I'm a nurse. I'm a nurse. Even okay, sorry. Can I say that again? I'm a caregiver. I'm a caregiver. So you don't have to be a nurse. You can be a medical assistant, a CNA, a certified nursing assistant. You can be in a social worker. I'm a social worker, or therapist, or psychologist, or someone who is taking care of someone all day, every day. And when you're done, put it in the comments so we can all leave little hearts by you, so we all know who our nurses are. I can't see. I can't even see chat right now. Bill, Bill is blocking everything. You know what? Half the people can't even read that because it's too damn small. Okay, now back to the video. About the video. So I saw these nurses and I was like, oh, they're in trouble. I'm gonna get this one. So this court case went on for a couple days. I got all of it, and all I really needed to show you all was the last like 20 minutes, and we would be fine. But no, I'm showing. I cut the whole week down into 2 hours, and we're gonna hear nurses talk for a bit, and then the ending, and then the end happens. And I've never seen this before, so let's just learn some medical shit today.
If you go in to have your blood drawn, but they're taking an order from a doctor there. So although there's no one on site.
Shit. Okay, so she used to work at this this nurse practitioner's office. So a nurse practitioner is a nurse with the training and education and the certification to write prescriptions. So he has his own practice, and he has a collaborating doctor who looks at his files like a couple times a month, to make sure he's okay. But him and his brother, it's actually his brother's practice. It's Daniel and David. I don't know. There's two brothers. One is the nurse practitioner who is fully licensed and legal. This guy is a nurse practitioner who lost his license and is not legal, but he stayed working at his brother's practice, supposedly as a medical assistant. And I don't think you'll hear this, but they sent undercover officers in there, and he was actually practicing medicine. So he's on the stand right now because he was practicing medicine after his license was revoked. And she used to work there with them. So she's actually a nurse practitioner now, but she wasn't back then. She was an RN back then. So this right here, this lady is the prosecutor. Now, you won't hear very much from his attorney. You want to know why? His damn attorney doesn't understand what a microphone is. So every time his attorney talks, he gets up and he walks the whole way over here. And you cannot hear a word. You can hear her answering, no, but you can't hear him. So I cut him out. I just completely cut him out. We won't see all the witnesses because it was a week-long trial. We wouldn't have time. He decides not to testify. So we won't hear from him at all, or his brother. So right now we're listening to a nurse practitioner who was a RN when she worked in his brother's office with him. Good?
Overseeing that, there's a written protocol.
And where do they find that written protocol?
Well, it can be actually put in the electronic medical record as an order, or there can actually physically be a SOP binder or some kind of written documentation on site.
Okay, so if there isn't a SOP somewhere, it would be in the electronic health record.
Yes.
Or it should be.
There should be some kind of instruction.
Otherwise, they do not have the authority to just independently make anything.
Based on their training, no, they don't.
So if I'm hearing you right, your medical assistants can see patients when you're not there?
Medical assistants can do basic patient care things like vital signs, weight, height, basic triage, but not assess, diagnose, treat, educate, those kind of things.
And what constitutes oversight on your part?
Again, it's really vague because I do feel there's a time and a place sometimes when a physician or someone who's able to have that kind of authority may not be physically in the building, but is reachable to give those directives. And again, I think that's going to fall kind of on the provider. Like, how comfortable is that provider with the ability of that medical assistant to really follow through on their directives and kind of, you have to have the confidence in that person. And I think it's going to be very provider preferential also. So I think, some providers are more comfortable with a little more laxity there than others. But I've never found anything in my research that says that there has to be a provider on site. From my understanding, they just have to be reachable, easily reachable to give that order to do whatever.
But how, I'm sorry to interrupt you.
No, you're fine.
How is it confirmed that that directive, that order came from the provider rather than just being done by the medical assistant?
Well, again, typically, I believe it should be at least in writing. So there is some kind of paper trail or some kind of proof that that order was given. But there are situations that I know of that happen pretty frequently where that's not the case, because verbal orders are still orders. So, my medical assistant can call the pharmacy under my directive. She can check with me. Is this okay for this patient to have 90 count rather than 60 count? I can say, yeah, that's fine. Go ahead and tell the pharmacy. And then she can relay that to the pharmacy. There's nothing in writing there, but it was a direct order.
Okay. Would you then make a notation or a record in the electronic health record as to what was done or ordered?
Should I? Yes, probably. But I think that documentation would be on the back end. That would be on the pharmacy's end. They're also making notes, verbal order given for X amount of medication by this person.
Let's talk about an appointment, okay, where a patient comes in and sees a medical assistant, and the provider is not there, and the directives all come from the provider as to what the medical assistant does or is implementing during that appointment.
Stipend. I apologize for interrupting. I've waited as long as I can. Try to answer out loud.
Oh, I'm sorry.
I've heard you say several times, which
okay.
is in the affirmative. I can tell that being here, but we are recording this, so try to answer yes or no.
Okay,
to the
I will.
questions.
That's my fault.
Sorry.
I should have corrected you. I apologize. I'll try to remember that. So would the medical record reflect your directive to the medical assistant? Or would it be written in such that the medical assistant would note that the directive came from you? Who would make an entry like that typically into the electronic health record?
I would. So in that exact situation that we just talked about, pharmacy, like a verbal order, or in the patient interaction?
In an appointment. So, and I guess the better question is this. Should there be an indication that two people were involved in that appointment, as far as the medical assistant being the person that roomed the patient and did certain things with that patient, and the provider confirming that
the treatment plan,
the treatment that was prescribed, if any medication was prescribed, all of that?
The way that usually works is the note should be signed by the provider in real time, time-stamped and signed with a sign-off key that belongs to that provider. So you know that they reviewed the plan and submitted it.
What happens when a medical record does not have an indication as to who makes that note?
Well, I think we know. Then we're not sure. We're not sure if it was reviewed, if it was, confirmed. It's kind of in a gray area there.
So you have to infer from the way that it's written who is actually making that note.
Yes.
Based upon the information that's
Thank you,
provided.
Salty.
Right.
Thank you so
And
much.
if it's presented in such a way that it is being written by the person that is not in the building, does it then become obvious who that person is that's writing that note? Or is that just assumption?
Well, in a medical record, you should be able to get in and see whose key the note was written under. So I guess that would be the second fallback, because each provider in an EHR has their own unique login information. And somehow, I don't know how all that would work in the IT world, but there should be a way to see that.
Okay, so let's talk about this. Are you familiar with telemedicine visits?
Yes.
There's a statutory provision that establishes what a telemedicine visit is. Is that right?
Yes.
And when did telemedicine, what is a telemedicine visit?
I think this became more of a mainstream method of healthcare through the pandemic, because we were not bringing sick people into our offices as frequently as we probably would have before. So telemedicine kind of became this really convenient option to do patient exams and visits without having to be physically in the same room together. So telemedicine, I believe in Indiana, I think it's a CMS requirement that it has to be video visit. So there does have to be like a video, audio and video component. But again, when you're operating kind of outside of those CMS guidelines, if it's not an insurance-based visit, that probably doesn't apply truly. But typically telemedicine, in a lot of cases, when you're actually evaluating, a patient physically, you need to see them. So you're face-to-face through a computer screen. That's telemedicine.
But it involves the actual provider, being the APRN, a physician, being involved in that actual visit.
I've never used telemedicine. Has anybody ever had a doctor's appointment through their cell phone? I feel like I should have by now, and I never have.
Yes.
It is not a visit where the provider is someplace else and the medical assistant is communicating with the patient and then after the fact communicates information to the provider.
I think that would, if it was a medical assistant, technically according to law, no, because it's not within their scope of practice to assess. An RN, now it's a little bit different because they are able to actually assess patients. They can't prescribe and they can't diagnose, but they can assess that information, relay it to a provider who then can kind of use that information to make a diagnosis and a prescriptive plan.
As long as you're healthy.
And you said telemedicine visits became popular in the pandemic, roughly like 2019, 2020. Would that be right?
Probably 2020.
Okay. So do you know if they were utilized much before, like in 2016?
Oh, yeah, I think they were a little bit, but definitely not as mainstream. I think they've been around as long as video conferencing has been around for computers. And I remember back, when I was in college, there was some Zoom capability and things like that. So I think it's been around. It's just not been as commonly used. So as far as medical records go, well, actually strike that. Tell us where you were employed prior to opening your own office. I was employed at Dan Tanner's office.
Okay, so you were employed at Concierge Medicine.
Yes.
And in fact, you actually were listed as a witness for the defense in this case, right?
Yes.
And I took your deposition.
Yes.
And decided to call you on behalf of the state.
Thank you. Yeah.
Thank you. But the bottom line is you're familiar with David Tanner and the whole concierge medicine.
I was hired to work in the Bremen office location. So I was a student prior to being employed.
And when did you work there?
2021, July and forward until, I guess, I don't know when all of this happened, but it's been about a year.
Okay.
Just over a year.
Is it possible that you were part of an appointment where the patient was the undercover officer that came in this case?
Yes, I in the probable cause affidavit, I was listed there and named there.
Would it strike you and would you have an issue with the date being March 4th of 2021 being his first visit?
I don't know exact dates at all, but it's been quite some time. But that would make sense. Mm-hmm.
Do you have any independent recollection of that appointment or that patient or anything about it?
I don't. No.
Okay. I may approach
So
Judge.
it's her fault they got caught.
Okay.
See what happens when they are not near a microphone?
Mm-hmm.
CJ. So this is why I cut all this out, and I missed some. So I'm gonna bump it forward until she's back at her seat. There we go.
Do you recognize any of that information being something that you entered or were involved in?
Specifically, no. I don't recall this patient. I thought back on this several times. I think it's a pretty vague and common complaint that happens in primary care, which is probably why I don't remember it. It wasn't something, stand out. No, I don't remember this encounter.
Is it possible to tell who answered that information? Controlled substances, tell the jury about prescribing controlled substances, just so that they understand the difference in the process.
So to prescribe controlled substances in Indiana, in most states, you have to have a DEA license. You have to be background checked, fingerprinted, vetted, and then you receive a DEA number, which goes with any electronic prescription that you send. It tells the pharmacy that you have that prescriptive authority, but there's always, when you're sending a prescription like that, that would be for something like, here's a name a lot of people know, Vicodin, okay, a pain medication. There's a two-factor kind of security process for that. So when you send that prescription, you enter in all the information, you sign it, but then there's a two-factor, a second kind of like gate you have to go through as far as confirming your PIN code, a separate PIN code on a separate device to prove that it's you that's sending that prescription, that not anyone else that you delegate is sending a controlled substance.
Where are all the nurses? Where's all my Viber nurses?
The two-step process really requires two different devices, or at least a different...
Well, you're attesting that you're using two different devices. There is a way around that probably, as far as just using one computer with a different kind of browser. But typically what I've always seen is people use a computer to send and then their phone to confirm.
And regardless, if you share your PIN, is that right?
Your PIN.
What are the two things you have to have in order to be able to prescribe?
What do you mean, licensure-wise? Or
to access electronically in order to prescribe?
So to get into the record, you have to have your login information. To prescribe a controlled substance, then you'll have to obviously be logged in. To send the prescription, you enter your sign password, and then you have to go through the controlled substance process, which is a separate PIN and login name.
If someone shares all that information with another person, somebody in their office, are you aware that people do that sometimes?
No, I'm not. I don't know of anyone that does that. Could you? Yes, you probably could, but it's pretty difficult because when I send a controlled substance, my phone is actually like the IMEI of my cell phone. And I know this because I've lost cell phones, and it's a pain when you get a new one to like re-authenticate it. My cell phone is somehow kind of like paired with the computer that I'm using to be able to authorize that. So it'd be really difficult. It would be probably impossible for someone to use a second device.
All I'm saying is, if all the nurses were in here, this chat would be going crazy right now. This was supposed to be different. All the nurses were supposed to start chattering about prescriptions and doctors who verbally give commands, and that's not what happened. That's just not what's happening today.
Apart from maybe the computer, which I don't even know if it would allow that. The safeguards on controlled substances are pretty tight. They make it pretty difficult.
Now let's contrast that with issuing prescriptions for legend drugs. And the reasoning for the distinction is basically what?
Legend drugs are typically not as harmful if you were to get them and you shouldn't have them. There's less typically on legend drugs, risk of dependence, risk of patient harm. A lot of these medications are meds that you can actually get over the counter. Like we can prescribe ibuprofen in 800 milligram doses, but you can also go to Walgreens and get a bottle of it in 200 milligram tablets and take 4 of them. So typically they're considered safer drugs that are not abused.
So it's less restricted in order to issue the prescriptions.
Right.
Now tell the jury the process for issuing a prescription for a legend drug.
So when you go in and you enter the prescription, all you have to do once you've entered all the details is click sign and send. And this is going to vary from EHR to EHR, but once you sign it, it requires your 4-digit or 5-digit PIN. You put in your PIN, you click send, and that transmits it to the pharmacy. So it's kind of confirming that somebody actually looked at it and reviewed it and sent it off.
Now, is that something that your medical assistants in your practice have authority to do?
Mine do not, no.
And why not?
Because I'm scared. Mostly because I feel that I don't want to ever have a medical assistant do that, make a mistake, and then number one, that liability falls on them, but always it would fall back on me as the licensed person.
It's your license.
So I want to take the fall for that. If I make a mistake with the prescription, at least I'm the one that's taking the fall there.
Now, are you familiar with some providers, practitioners that do have their medical assistants issue those scripts for them?
Yes.
Is it fairly common practice or?
I haven't worked a lot of places, so I can't say it's common, but I do know that it's not uncommon. It's not unheard of because some providers are seeing 30 patients a day. They don't also have time to authorize their prescriptions between those visits.
It's a provider's choice as far as legend drugs are concerned.
Yeah, it's comfort level. Mm-hmm.
Are you familiar with how the provider at Concierge was Dan Tanner? Is that right?
Yes.
Mm-hmm. And I do have a question. Are you familiar with Maggie Tanner Ponto?
Yes.
What is her license status, or what was her license status back in 2021? Do you know?
She was a registered nurse, RN.
When you were working there?
Yes. She was in nurse practitioner school.
Okay, so she ultimately has become a nurse practitioner?
Yes.
And that's what she is today?
Yes.
Mm-hmm. Okay, so she's the same designation as you?
Correct.
And her dad?
Yes.
What was the practice at Concierge as far as Dan's information for issuing legend drug prescriptions, or just prescriptions in general that were not controlled substances?
Mm-hmm. That is
not you.
A good question. And I've thought back on that. If I can recall a moment when I ever saw him have someone else send a prescription, or, I mean, I never verbally heard him tell anyone to do that. So I don't know. And again, as a student, I was there 1 or 2 days a week. So I didn't see a lot of that. So I guess I can't really attest to exactly what happened in those situations.
Is it possible, though, if someone else in the practice had his identification, that they could issue a prescription for a legend drug?
I wonder how they got caught. So Daniel, I think, owns the whole practice, and he is a registered nurse practitioner. His brother David, or Donald, or I don't know his name, was revoked, so he was supposed to be as an RA. So what they're saying is that any prescription that the brother sent in or wrote or whatever was at Daniel's request. He called him or did a teleconference or got verbal orders from him to send this in. But a police officer, an undercover officer, went in to investigate. How? Why? Why did the undercover officer think to investigate that? Did someone tell? You think someone from the office told on him?
Without him being a part of it?
Yes.
If I may approach, Judge.
You may.
Thank you. I need verbal orders for issuing prescription.
Mm-hmm.
Was there anything in the May 14th record that indicated a verbal order had been given to the medical assistant to issue the prescription?
In the medical record, no. But if it was a verbal order, there may not be anything in the medical record.
Well, it says information relayed by office staff.
Mm-hmm.
Why would there be that indication without the correlation to a verbal order that was given to issue the prescriptions that are referenced in the medical record?
I think a lot of this hinges on, honestly, best practice versus real life practice. So in the medical world, there's an art and a science, right? So there's a lot of gray area, and a lot of people don't like that fact, but that's how it is. So there's best practice, and then there's the way sometimes things actually go. I don't know in my mind if it's as simple as black and white there.
Well, let's put it this way. There's a hypothetical for you. Is it possible that from this record that Daniel Tanner had nothing to do with this appointment?
It's possible.
Is it possible that David Tanner is the only one that was involved in that appointment on May 14th?
It would be possible, yes.
And you said something about there's two ways of reading that note about information relayed by my office staff, and possibly the most logical way is that it goes towards the information is relayed by office staff to the provider.
Mm-hmm. Or to the patient. It could go either way.
Either way.
Yeah.
Is it possible that this was just a cover to show, to cover that David Tanner handled this patient by himself without any control?
Possible. It's possible.
Thank you. I have nothing else.
Cross?
Isn't just about anything possible?
Yes. Yes. In the medical world.
Hold on a minute. Sorry to interrupt, but there's no question for you at this time.
Okay.
Just type and redirect.
No.
Questions from the jurors at this time of the witness. You can write down the questions. I'll give you a moment to do so.
It's a full jury trial. So the jurors are writing down questions to ask.
I see no pencils moving, maybe a couple. There's at least one question possibly. These are questions of the jurors. And this is, again, the first one that's rather lengthy, but I'll read through it all. Are you ever referred to as doctor in your practice by your patients? If so, how do you respond? Do you correct your patient? If so, do you make that correction sometimes or every time, and why?
Yes, often I'm referred to as doctor because a lot of patients either assume that the person who's able to send their prescriptions is a doctor. That's kind of just,
Probably.
I guess, the typical person that over many years, people get used to sending their prescriptions. I correct them every time. Yes. Although there can be a doctor designation in the nursing field, there are a lot of APRNs that have their doctorate and can be referred to as doctor. You can't claim the title medical doctor, but you can accept the title of doctor if you've earned that degree and that educational level. I have not, so
I started my doctrine and then I quit. My doctrine, no way.
I don't accept that title.
Thank you for your response. Next question is, what protections does a patient have that they are being treated by a licensed professional?
Well, licensure is public knowledge in the state of Indiana. You can go online to PLA Search and Verify and type in someone's full name and you'll be able to see that they're fully licensed. So it is public knowledge. I think a lot of people don't know that. You can search their NPI and you can always ask. And you have to be forthright with that information if someone asks.
Thank you, ma'am. Next question, and I'm going to qualify this question. It is for the time period in which you worked for concierge medicine.
Mm-hmm.
The question is, did you know David didn't have his RN license?
I did not know that. No.
She did
Final
not
question
know that.
from the jurors at this point is, can MAs get permission by provider over the phone / electronically for
MAs are medical assistants who are not able to diagnose, treat, teach, prescribe. They're not allowed to do any of that.
new prescriptions, not only refills?
Can you say that one more time?
Can MAs get permission by provider over the phone / electronically for new prescriptions, not only refills?
If they get a verbal order, yes. They cannot issue those without a verbal order or a written order.
Thank you. Ms. type and redirect on those questions.
If it's a new prescription that's been verbally ordered, would that be indicated based upon a diagnosis that verbal order was given? It should be noted, or how do you know?
Yes, there should be some kind of documentation to back up that diagnosis.
Was there any indication of that in this record that you reviewed, that you recall?
Assessment data, you mean?
The electronic health record, as far as the May 14th appointment went.
Well, I mean, yes, there was assessment data, but what's in question is who did the assessment, right?
Correct.
Yeah.
But there's also no notation that a verbal order was given over the phone for a new prescription based upon the new assessment.
Correct. That's not in the medical record.
I kind of have a question going back a little bit, if I could, Judge.
Is it an omitted question from your direct, or is it related to the juror questions?
It's related, I think, to the juror question. But you know what? I'll withdraw it.
It's okay. You can approach it and I can go over the juror questions with you if you need.
It's okay.
Any other questions then?
No.
Cross on.
Thank you. Let's put that one question about if you were referred to as a doctor in a little bit more isolated context. Suppose it was a passing reference. So, for example, if someone said, I appreciate it, doc. Mm-hmm. Not like constantly referring to you as doctor, blah, 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 right? Mm-hmm. Dr. Prendergast, whatever. Yes. If it's a passing reference like that, which you may or may not have even caught. Mm-hmm. And let's say, for example, also that just a few minutes earlier, you'd introduced yourself to the patient as a nurse. Mm-hmm. Is that something where if you introduced yourself as a nurse, and then the patient just said, I appreciate it, doc.
That happens. It happens all the time. Okay. All the time.
Under those isolated circumstances, then, and let's say the individual's dressed not in a lab coat, or somebody says MD for me, doctor, that it's a polo shirt. Mm-hmm. If in that context, then, is that something where you'd be as concerned about disabusing the person of the idea you were a doctor?
No. I think there's a time and a place for that correction, but it's really irrelevant at that time. If they in passing call you doc and you don't say, oh, wait, I'm not a doctor, I'm a nurse practitioner, I don't have full medical training. Like, could you say that? Yes, but to be not socially awkward, I don't know that you'd stop the conversation right then to confirm that.
Thank you.
Other questions, Mr. Stanko? Mr. Stanko, other questions?
No questions, Your Honor.
Redirect on that?
I do.
It has not stopped for me. It's still going. I just learned how to not be socially awkward. So when people call me a doctor, I should just let them go and let them think that I am, in fact, a doctor.
What do you think of someone that is not a licensed nurse, RN, LPN, CNA, whatever, any kind of designation, introducing themselves as the office nurse or a nurse for the office?
Nurse is a specialized title based on training and licensure. So you shouldn't call yourself a nurse if you're not a nurse.
Licensure and education.
Yes.
Correct. Nurses. If we're talking about a nurse in any capacity, is licensed. CNAs, no, they are not licensed. Medical assistants are not licensed.
And so someone in a capacity as a medical assistant should not be referring to themselves as a nurse.
No.
Does that, in your opinion and your experience, does that give the public, patients coming into the office, an improper thought regarding the people that are providing care for them? What is the concern exactly by somebody misrepresenting something like that?
Well, the misrepresentation would be the concern. I guess calling yourself a nurse conveys a higher level of training and licensure than a medical assistant. So maybe more capable.
Does it give patients more belief in what is being represented to them, potentially?
Yeah, because in our society, titles have credibility, you know?
And if you ultimately are making a diagnosis or prescribing treatment or telling somebody that they have carpal tunnel syndrome, or they don't have carpal tunnel syndrome, does that then lead them to believe that you know what you're talking about?
Calling for speculation, Your Honor.
Response?
Potentially.
I'll sustain the objection. You can rephrase the question.
What are the concerns for what a patient might think of someone that is representing themselves in a capacity that they're not regarding the potential care that is being recommended or the treatment that's being recommended?
Well, I guess if I would.
Excuse me, Your Honor. Again, that's calling for even more speculation.
I actually disagree on this one because she asked in a way that was about the credentialing and then what are the risks of that, not a specific hypothetical instance. So overall the objection, you can answer.
Will you say it one more time?
I will try.
I'm hungry and now I forget.
So do I. What can be the potential effects or results of somebody misrepresenting their abilities on a patient's, I can't remember what I asked you, I'm sorry.
No, I said that's what women do. Because that guy was complaining that all women are against him. So I was sarcastic and I said, yes, all women wake up and plan every morning how to find a way to get at men.
Remember how I put it. I'm too tired.
Does that mean you're giving up?
I'm giving up right now.
Withdraw the question.
I withdraw the question.
Ms. Prendergast, first question is, did you know the designation of Dan Tanner and any other staff members?
Designation as in licensure?
I'll allow you to answer that as you see fit.
I'm assuming that means licensure. Yes, I knew the licensure of Dan. Should I address them or you?
Whatever you feel most comfortable with. It's
Okay.
a question of the jury, so you can address that.
Yes, I knew his licensure simply because I had to submit all of that documentation for my educational program to get approved to do hours with him. So yes, I had to have a physical copy of his license that I submitted. So I knew his licensure. Within the rest of the office, no, there would have been no reason for me to ask for that information. So I would have had no way to confirm their designation.
Did you ever hear Dave Tanner say he was a nurse?
I've thought back about this many times and tried to recall a moment that I actually heard him verbalize that actual word, and I don't recall.
Thank you. Redirect on that?
Thank you. How many times were you in a room with the patient with David Tanner?
Your Honor, that's beyond the scope.
Overruled.
Thank you.
You can answer that.
Not often, because I wouldn't have had a reason to follow him into
So, Rich, how was Dr. Davis?
a room
Okay.
because I wasn't training to be a nurse, MA, anything else. I was training to be a nurse practitioner, so I typically didn't room patients.
And you worked primarily in the Bremen office.
Right.
Mm-hmm. So how often do you think you were in Plymouth, the Plymouth office?
Oh, working rarely. As a student, 1 or 2 days a week, but rarely in the Plymouth office.
Okay. And did David ever go to the Bremen office when you were there?
No.
All right. So it was pretty minimal contact with David Tanner.
Yeah. Mm-hmm.
I have nothing further.
No questions, Your Honor.
Thank you. Likely closes out the juror questions as well. I don't see anybody writing, so I think we can move on. Thank you. You can step down, ma'am.
Thank you.
Watch your step. Join us. Have a seat, folks. We were in the middle of the state's case in chief. Can you call your next witness?
It calls Dr. Walter Fritz.
Could you call Mr. Fritz into the...
All right, Dr. Walter Fritz is the doctor that is collaborating with Daniel. So for a licensed practitioner, nurse practitioner, you need to collaborate with an actual doctor, an MD, to run a practice. So this is the doctor that checked over all of Daniel's work.
Dr. Fritz into the office. Right?
He is definitely on the Fritz. Absolutely. He's coming. Give him a second. He's coming. There he is. Almost. Whoever hoped he fell there is evil,
Questions of the
guys.
witness?
Don't be like that.
Good afternoon, Dr. Fritz.
Good afternoon.
Thank you for coming today. Been here it's been a long day here for you, right?
Yes, ma'am.
Can you start by stating and spelling your full name for us, please?
Walter, Walter, Fritz, Fritz, MD.
And how long have you been a doctor?
Approximately 53 years since graduation from medical school.
And are you currently practicing?
I stayed in practice in Knox 50 years, retiring completely in August last year.
You were listed as a witness for the defense in this case. Is that right?
I believe so, yes.
And because of that, I did a deposition of you. Do you remember that?
Yes.
And why were you listed as a witness in this case? Do you know?
I am related to Dan Tanner by means of a physician being his collaborating physician to allow him to practice medicine as a nurse practitioner in the state of Indiana.
And that's his business is concierge medicine of Marshall County. Is that right?
Yes, it is.
And how long have you been collaborator for his practice?
Approximately 10 years.
And what is a collaborator?
The main function of a collaborating physician as it relates to the nurse practitioner is to supervise the quality of the medical care that that nurse practitioner renders by means of chart review on a periodic, ongoing basis.
And is that a quarterly chart review, monthly chart review? How does that work exactly?
On a regular, periodic, recurring basis. I'm not sure whether the Medical Licensing Bureau regulations require a certain specified frequency, but it's every few months, certainly.
And about how many charts do you review per year or so, you think?
100.
100 total for the year?
That's a rough guess.
Okay. And how do you get those charts?
Daniel Tanner delivers them to me, and I review them, and we have a conference where they're discussed together periodically.
Like by telephone, or do you come in person? Or how do you discuss the charts?
One-on-one the following time around. That gives me time to review them when he delivers them to me. For anything of an urgent or emergent nature, that would merit a phone call. And during the approximate 10 years that I've done this with Dan, I've not had any need to make an emergency phone call due to any of the findings.
Are you familiar with telemedicine visits?
Yes, I am.
Can you tell the jury how telemedicine visits are supposed to work?
in terms of the word visit, this is relating to a patient interacting with either a doctor or a nurse practitioner on a face-to-face basis. The most common visits, of course, are rendered in the doctor or nurse practitioner's office. With telemedicine, that interaction, both on a face-to-face basis and verbally live, is rendered by means of electronic equipment. The physician, from my standpoint, sits in front of a computer with a microphone and usually interacts with the patient, usually with a cell phone, which gives an instant image on the physician's computer, and vice versa. That's done in real time. Telemedicine differs from just simply talking with a patient on a telephone. It involves seeing the patient, looking at their reactions, their facial expressions, above and beyond which is able to be done by means of a simple phone call.
If I may approach, Judge.
You may.
I missed one again. I'm gonna fast forward it till she's sitting down.
2016. Ever seen this document?
There we go.
From my personal standpoint, it seems the correct term on that document would or should or could be or have been collaborating physician instead of medical director. But nonetheless, in answer to your question, a medical director is someone associated with a medical practice who has at least some degree of supervisory capacity and capability of running that practice, both from the operational standpoint and assurance of quality.
Have you ever operated concierge medicine as a medical director, running it, in charge of it, in control of it?
No.
You've merely worked as a collaborator reviewing documents that have been provided to you.
That is correct.
How do you know David Tanner? Or do you know David Tanner?
I first got to know, I know very little about David Tanner. I've got to be careful not confounding David with Daniel. David, I believe to be the brother of Daniel Tanner. Daniel, at some point in time in the last few years, mentioned that he would be providing some type of medical service at his office from the standpoint of a medical assistant.
How long have you known Daniel Tanner?
20 to 30 years.
You consider Daniel to be a good friend, is that fair?
Yes.
And you learned about David and David's involvement. Strike that. Did you become involved in the development of concierge when Daniel Tanner was looking at getting it started?
Yes.
He consulted you as a friend, as a physician, and involved you as his collaborator. Is that a fair assessment?
Using the word collaborator in that instance in the broader sense of the term. Yes, that is correct.
I want you to remember that. I want you to remember how she used the word collaborator, and he took exception to that. He's going to say why, but try to remember that.
Well, then you became the collaborator for the practice itself.
A collaborating physician is a very specific label or term defined by our medical licensing board. Yes.
Forgive me for that. What David Tanner's license status? What do you understand his license status to be?
As of today, to the best of my knowledge, I understand David Tanner's legal association with concierge practice as that of a medical assistant and not as a nurse practitioner.
Okay. When you were deposed, you indicated that you believed David Tanner was an APRN. Is that right?
That is correct. And that was an error on my part.
So you have learned subsequently that?
Yes, I have. That's the only major error that I understand from that deposition that occurred about a month ago.
You were deposed on February 12th, right?
That is correct.
And you were told that David Tanner was an APRN by Daniel Tanner. Is that right?
No, that was not right. Daniel Tanner told me that David Tanner was associating with his practice, as best I believe, from the medical assistant standpoint.
You don't remember telling me that Daniel told you that David is a licensed nurse practitioner?
That's the one major error I made due to lack of recent memory with this particular case a month ago at the time of that deposition. That is correct. I made a mistake in stating that at that time.
I'm just trying to clarify that. Are you saying that Daniel Tanner never told you that, or that you misunderstood?
Daniel Tanner never told me that his brother would be associating it in his practice other than as a medical assistant.
This is the prosecutor getting a huge
I may
blow.
approach.
You may.
I'm going to show you. Starting there. You can go through.
What I'm recorded as saying in this deposition, which is correct.
Well, the question is, the question before you is, did you make these statements? Did you answer the questions
This
way?
deposition papers are correct.
Never, ever, ever walk and never, ever, ever fall down in Micah's lawn.
Written form of what I had said erroneously at that time.
So you don't dispute that you said this?
No, I do not.
What you're saying today is that
I made a mistake.
okay, but I think what's important is the question before you was, okay, are you familiar with what David's qualifications or what his current status is, or what his status was back in 2021 as far as what he was allowed to be doing as a provider or as? Your answer was, as long as he was licensed by the medical licensing board, and to me that is the sine qua non, as long as he passed their hoops and hurdles. No, I don't recall what college he took his training at, what examinations he's passed. I think he's just recent in practice compared to his brother, Daniel. Question, okay, so but your answer, but no, I don't know much beyond the fact that he's a licensed nurse practitioner. I trust Dan enough even though there's some connection of nepotism involved to take him under his wing. Question. So your understanding from Daniel is that David is a licensed nurse practitioner. Answer. By means of the medical, I believe that's the
Hey, Zach, wrong account.
correct term. Yes. And that's what Daniel told you? Yes. All right. And I'm not trying to argue with you, sir. I'm just trying to make sure that what you said there, you're not disputing that what you said there was correct at that time.
That is correct,
Okay.
because just prior to that time, I had undergone a period of a number of months of medical illness where I was not involved much with that practice. And during that time,
Hi, Willie.
I had lost my memory distinction between David being a medical assistant as opposed to incorrectly a nurse practitioner, which is what I had said a month ago.
So when did you realize that what you had said in this deposition was incorrect?
In the last few weeks, I have had clarification of that from multiple sources. And that matches, in retrospect, what I have known all along over the last 10 years. When I testified at the deposition, I had not done any preparation. I thought I had remembered everything well, but due to my absence of contact for several months prior with this practice, due to my own personal medical illness, I made a mistake. And I admit to that today.
Well, and you were subpoenaed by the state of Indiana to be here today, correct?
Yes, I was.
And my information was on the subpoena that you received. Is that right?
Yes, it was.
And you did not contact me prior to this trial to inform me of this change in information that you realized was incorrect in your deposition before coming today to testify. Is that fair?
I did not do that because I was not aware that it was a mandatory requirement.
That's fair. I have nothing further.
Ross? Just very quickly, Dr. Fritz, the specific date involved in this particular case is March 14th of 2021. On that date, were you the collaborating physician for Concierge Health?
Yes, I was.
That's all I had. Thank you.
Redirect on that.
Dr. Fritz, I have one more question. Who told you were wrong?
I was both reminded of that. My memory was refreshed. You can use the term "told me that I was wrong," and that is another way of saying that by both Daniel Tanner, primarily, and Mr. Paul Stanko.
And Daniel Tanner was not present for that deposition, was he?
No, he was not.
Thank you. I have nothing further.
So,
Speak cross on that.
remember when I said, remember that, remember that? Okay. She used the word collaborate, and he right away jumped on her, the collaboration, because the term, he was a specific collaborating physician. You can't call him anything else because that's what he was. So, and I mean, he seems like a stand-up guy, so he doesn't seem like someone who will lie. But when they asked him why he got it wrong, he said Daniel told him Dave was a licensed practitioner. Now, you don't mix that up with medical assistant. You just don't. And when he explains how he did mess it up, he said the exact same words almost verbatim each time they asked. Like he's been practicing it. Oh, well, I forgot why I was on there, and my mind was refreshed, and I got into an accident. I have short-term memory loss, so I just think he's up there lying, which is crazy because I never would have expected him to lie, but he's doing it.
Dr. Fritz, we did subpoena you to testify today, correct?
Yes, you did.
Okay. And prior to that time, did I discuss with you briefly what you might be called upon to testify to?
Yes, you did.
And did I indicate that I would be asking you if you were the corroborating physician or collaborating physician, for Concierge Health during this period of time?
Yes, you did.
And in that conversation, did we perhaps indicate that David Tanner was not a nurse, but rather was a medical assistant?
Yes, you did.
That's all I had. Thank you.
Good night,
Dr.
Willie.
Fritz, these are questions of the jurors here. I'll ask them as follows. First question is, how were the charts delivered to you?
The charts were all delivered to me personally by Dan Tanner.
Second question is, when did you remember that you changed your mind and who all helped you?
I had, this was within the last 7 days. I had conversation with Mr. Paul Stanko and Mr. Daniel Tanner, both in regard to that.
Thank you, sir. The next question is, can an office visit with an MA be considered a telemedicine visit?
No. A medical assistant
Wake up.
does not rise to the, in my opinion, does not rise to the level of being able to provide an office visit that a nurse practitioner or physician MDDO would.
Thank you. You direct on that?
Just a couple things. Dr. Fritz, at the conclusion of your deposition, I served you with a subpoena for trial today, or yesterday.
Yes, you did.
Yes, it was. I did serve you at the deposition, though, on February 12th, right?
Yes, you did.
And were you contacted about making this mistake?
Yes, I was.
Okay, so it wasn't something that you just independently
No,
remembered.
I completely was mistaken due to my lapse of recent contact with the practice and my medical illness to account for just that.
And who contacted you first, Paul Stanko or Dan Tanner?
Dan Tanner.
And just to clarify, medical assistants are not qualified to be doing telemedicine visits independently.
According to the definitions that we've agreed upon, that is correct. They can relay information, but in terms of the provision of a quote office visit, I do not believe so.
And a provider needs to be face-to-face with a patient for a telemedicine visit.
Correct.
Thank you.
In my opinion.
Thank you, doctor. Well, is that what the statute requires?
I believe so.
Correct. Thank you very much.
Cross on that.
Just a moment. Doctor, you've been practicing a long time, correct?
50 years.
That's a long time. And would you agree that your opinion about what telemedicine can or can't be may be affected by the fact that you've been practicing for a long time, and it might be different from people who have only more recently started practicing? Would you agree with that?
Most probably so, yes.
Now, if you were told that there's a statute, definitions under Title 25, and under diagnosis diagnosis, there is a subsection that says it is not necessary that the examination be made in the presence of the patient, may be made on information supplied either directly or indirectly by the patient. Were you aware of that fact?
No, I was not.
Okay. And that may be a little bit ambiguous or vague, but isn't it true that that could be interpreted perhaps by other professionals as meaning that televisiting does not require face-to-face communication between the doctor and the patient?
It potentially could be, yes.
Okay. And that's just an opinion, correct?
That's correct.
Thank you. That's all I have.
Redirect on that.
Yes.
Come on, this guy is ready to take a nap. Let him go.
Would you also agree it's the same statute that says the term telehealth does not include a healthcare service provided by, one, an employee of a practitioner, or two, an individual who is employed by the same entity that employs the practitioner who is performing a healthcare service.
What?
I'm a little confused by that, but it sounds reasonable to me.
Well, what that means is telehealth does not include a healthcare service provided by an employee of a practitioner.
I'm of the opinion that a nurse practitioner, licensed nurse practitioner, can be an employee of another nurse practitioner.
Well, an employee, though, meaning a medical assistant.
Okay, that's where I don't understand fully. That differentiation is regarding the statute.
Do you know what a practitioner is defined as?
No, I do not.
Okay, I have nothing further. Thank you.
Nothing for you.
I saw one question already, so I will give a moment here. Please raise your hand or your pencil if you have a question. That way I can either move on or wait. Council, can you approach? Okay. We had to weed through these questions here, and a series of them will be asked. Doctor, these again are questions of the jurors. The first question is, were the charts delivered electronic or paper?
They were delivered manually by hand in terms of the paper record, not electronically.
This next question is as follows. Who is Paul Stanko?
I understand Paul Stanko is an attorney representing David Tanner.
Thank you. The other series of questions were deemed inadmissible. Redirect on that.
Did you talk to Paul Stanko on the phone?
I don't remember. I've seen Paul. I don't remember. It could be both. Certainly face to face, briefly.
Don't trust those women, Sonel. Don't trust them.
But I don't recall whether I got a phone call from him.
Do you know why you're here for trial today? Do you know why you are here today?
Because I've been subpoenaed as a witness for this trial.
Okay, what trial is this?
This is a trial of David Tanner.
Do you know who David Tanner is? I mean, do you know him to visibly see him and recognize him?
This is the first time I've seen David Tanner in person today at the trial.
Okay, so you met David Tanner today?
I've seen him walking by while waiting these hours in the witness area.
Okay, so where is David Tanner?
Where is he?
Is he here in this courtroom?
From what I've learned today, I do not see him right this minute.
Okay.
He's right here.
You see Paul Stanko in this courtroom?
Right there.
Yes, I do.
This is Paul
Okay.
Stanko.
Where's Paul Stanko?
He's sitting 2 chairs to your left.
Okay. I can just have a minute, Judge.
Take your time.
The prosecution was depending on him because he said words that he doesn't remember.
During the deposition, we talked about the policy manual for concierge medicine. I showed it to you, and I brought it to your attention about being the medical director, that you're listed as medical director.
I believe that's correct, yes.
And you indicated you were never the medical director, you were the medical collaborator.
I was the collaborating physician, yes.
At the deposition, you learned that that indication was in that policy manual in error, right? It was wrong. You were not the medical director.
I never did come to an opinion during the deposition in regards to that statement that you've just made. I recognized it being present, but I did not believe I expressed any opinion during the deposition that it was incorrect.
You don't remember telling me that you were not the medical director ever, like you testified today.
I might have, I just do not remember.
After you learned that was in that policy manual, did you bring that error to Daniel's attention?
No, I did not.
Is there a reason why you did not?
Completely put it out of my mind.
Or he was coached. To say
Do you
he was
remember
wrong.
who all was at the depositions when you were testifying back in February?
I certainly remember clearly that you were. I certainly clearly remember that Mr. Stanko was. And another attorney, Mr. Chisinski, I believe, was also present. Those are the 3 that I can personally identify. I'm not sure of any others. I could be reminded and remember a little bit better, but those are the only 3.
Thank you, Doctor.
Thank you. Cross.
Doctor, do you occasionally have memory lapses?
Yes.
Okay.
My wife tells me frequently.
I have nothing further.
Redirect on that. Other questions of the jurors? And I see some heads nodding no definitively. So I also see no pencils. If you are formulating a question, raise your hand. I don't see any. Thank you, doctor. Free to step down. Careful to step down.
Be careful. Go slow. Oh, that's exactly how I stand up.
Mr. Stanko, your questions.
Thank you. Could you state your name for the record, please?
My name's Alexander Getsimas.
Okay, I think this is a doctor that they have on the stand as an expert witness on how telemedicine and medical assistants and practicing nurses, licensed nurses who can write prescriptions, how it legally all is supposed to work.
And you've been called and subpoenaed to testify by us in this case, correct?
Yes, sir.
What is your current occupation?
I'm a physician.
And where's your office located?
It's on Edison Street in Mishawaka.
Okay, and that's in St. Joseph County, correct?
Yes.
Now, to make this as efficient as possible, could you state for us briefly what your college or graduate degrees are and from what institutions you obtained them and what year?
Sure. I attended Tufts University in Boston. I graduated in 1982. Went to Tufts Medical School in Boston, graduated in 1986. I went to law school, graduated from Valparaiso University School of Law in 2006.
And the degrees you got from the medical degrees, were that medical doctor?
Yes, Doctor of Medicine, MD.
And the legal degree was a Juris Doctor?
Yes, JD.
Okay. How long have you been practicing medicine?
I graduated in 1986, so about 37 years, minus the 2.5 years for law school.
Have you testified previously in a court proceeding?
Yes.
Okay. And you recall us having a deposition with all counsel present about a month ago, correct?
Yes, sir.
Now, the purpose for your testimony today, from our perspective, is to testify about telemedicine or remote medical care and the way it's conducted and the appropriate parameters for doing so. You understand that?
Yes.
Now, just to move things along a little bit, has the practice of medicine changed since, let's say, 2019, 2020 in the wake of the COVID epidemic?
Yes, it has.
And how has that changed?
Obviously, with the advent of COVID, social distancing, keeping your space, Medicare approved telemedicine. Previous to that, there were very strict regulations on telemedicine. During the COVID pandemic, the rules of telemedicine were liberalized significantly to incentivize us not to bring sick people into the waiting room where they'd cough on other sick people. And so telemedicine kind of, you can think of it almost like working from home on your computer, okay? Nobody even thought about that. And now after COVID, a lot of people today continue to do that and are at the office part-time. So telemedicine became more favored for a while, and it's beginning to run its course a little bit, but is still very prevalent.
Okay.
Judge, I would object at this point for purposes of formulating an objection. I'd like to do some voir dire.
You may.
Dr. Katsimas, we did a deposition. Is that right? Back in February?
Yes.
And I asked you what the basis of your testimony was going to be at that time. Do you remember?
Yes.
At that point, you didn't know what your testimony was going to be. You thought it was basically the general practice of medicine.
Correct.
Right? And I asked you about your experience and understanding of telemedicine. Do you remember that?
Yes.
And do you remember what you said to me?
I believe I told you that I don't practice telemedicine in my practice.
So do you do telemedicine examinations or visits with your patients? And you said no. Why not? Number one, I'm not a technology person. Number two, I'm in the office all the time, and you know it's just something that I've never picked up. My next question, are you familiar with how they work generally, or what the rules are for doing telemedicine? Not so much. So that's going to be the form, that's going to be your testimony today, is about your expertise in telemedicine?
I don't know what Mr. Stanko is going to be asking me. I do know generally how telemedicine works. I believe further in that deposition you inquired, and I told you that my electronic health record did have a telemedicine module. I had not purchased that, but I do know the general parameters on how people that do telemedicine. I generally select not to do that. I did during the COVID pandemic out of necessity. I prefer to personally care for my patients rather than doing it electronically.
You just started talking about your background and understanding of telemedicine, and you did not indicate any of that during your deposition. Is that fair?
You asked me if I practice telemedicine. I told you no. You asked me about specifics of telemedicine, and I believe I told you I'm not a technology person. I certainly am not. I know generally what's done and how it's done. I know certain of the Medicare regulations about it, but I do not practice telemedicine significantly, no. Not since COVID.
Also, you said, I asked you how many times you've testified as an expert. Is that right?
I believe so.
And how many times did you tell me that you testified as an expert?
As an expert, I believe I told you no.
Well, you told me one other time.
Do
you recall?
I don't recall.
That's fair. And I asked you how many times you've testified in total. Do you remember what you said to that?
I think I've testified a few times in court.
Half a dozen, 5 or 6.
Sounds
Sound right? Can we approach, Judge?
You may. Ladies and gentlemen, I've sustained an objection, and Mr. Stanko will be permitted to rephrase his question.
All right, Doctor, as an MD, are you aware of the limits and abilities of various types of practitioners within the medical professions?
Yes.
And is there a hierarchy of responsibilities and capacities among different types of nurses, for example, medical assistants, medical doctors, advanced practice nurses?
Yes.
Now, with a medical doctor, is that capacity essentially unlimited within their areas of expertise?
Pretty much. And I would include in that guy's MDs, allopathically trained medical doctors, MD, doctor of medicine, as well as osteopathic physicians, DO, doctor of osteopathy. And then a step down from that, nurse practitioners, advanced practice nurse.
What, within the parameters of the law in Indiana, as you understand it to be, what are physicians and osteopathic physicians permitted to do?
Pretty much anything within their realm of expertise, as long as they're engaged in a legitimate practice of medicine.
And with that,
No. So this trial was a week long. It was. I've been getting it for a couple of days now, but we're not watching the whole trial. We're just watching a 2 hours of little clips from him until we get to the end. The end is so good. We're almost there. We're almost to the part where it starts getting good. We just have to get through. Once this guy is done giving his testimony, which I included because nurses would love his testimony, but very few of my nurses showed up at the beginning of this stream, or this stream would have went way different. But this stream was for my nurses, my vibrant nurses, doctors, caregivers, mental health, physical health, people who spend all day caring for other people and have to deal with doctors. So this stream was all for my nurses, but my nurses slept in today, which is fine because I love when nurses sleep. It makes me happy.
include holding themselves out as a member of that profession to the public?
Yes.
Would it include
Yes,
diagnosis,
you are.
treatment, correction, and prevention of disease?
Yes.
Would it include suggestion, recommendation, and prescription of treatment?
Yes.
Would it include performing of surgical operations?
Yes.
And would it include prevention of physical, mental, or functional ailments?
Yes.
Now, with respect to persons on a lower hierarchy, shall we say, if they're under the supervision of a physician or osteopathic physician, are they permitted to do certain things under the direction and supervision of that physician?
Yes.
Does that include diagnosis of a disease or illness?
They can take a history. They can make. They can surmise, and I would say yes. Although in my medical practice, the formal diagnosis is something that I render.
Okay. Now, how does that work? First of all, do you have any medical assistants or other employees that work under your direction?
Yes, I employ medical assistants that work for me.
Are those medical assistants certified?
Yes, they are.
Now, is certification of a medical assistant required in Indiana?
No, it's not.
Are there some states that do require it?
I don't know that.
Okay. But in Indiana, is that the only place where you practice?
Yes, it is.
And as far as you know, medical assistants do not have to be certified?
Correct.
What sorts of things can a medical assistant do so long as it's under your direction and supervision?
And conventionally, medical assistants will, if you're sitting in the waiting room, the medical assistant will bring you back. The medical assistant will take your vital signs. They'll check your weight, your respiratory rate. They'll check your blood oxygen level. They'll check your pulse rate, blood pressure, etc. They will, quote unquote, room you put you into the examining room. They'll usually take a patient-focused history. Why are you here? What's your chief complaint? Tell me about it. And they will usually talk with the patient. Then they will make notes on the chief complaint and so forth, and then write that down and sometimes tell me what's going on with the patient. And that's not just redundancy. A lot of times the medical assistant has more time or a different type of relationship with the patient, and thusly sometimes the patient will tell the medical assistant things that they won't tell, quote unquote, the doctor.
Now, in my experience, I think everybody goes to a doctor. Sometimes I find myself being taken back to an examining room. It may be some time before I see the physician, and I may see a plethora of other individuals, and perhaps one's some sort of an assistant or a student and maybe a nurse or whatever. Is that common in a practice?
Yes, it is.
And is that possibly to alleviate the time when a person is simply just sitting in the waiting room, not getting anything done?
It's a couple of things. There's different levels of care and information to be procured. Number one, for example, the medical assistant has more time to talk colloquially with the patient and converse with them. The physician, the practitioner, usually has time constraints. You've got a lot of people waiting for you, et cetera. So some of the socialization, which sometimes leads to very important information, that information can be procured by a medical assistant that the doctor's not going to have. At the same time, if it's a teaching facility or an academically associated practitioner, I've had students rotate through. I have nurse practitioner students rotate through. I have a resident physician who works with me. Then there's a pedagogic educational aspect. You have the young physician take the history. So when you see the patient with them, they have taken history, you get the information, and it's a learning experience. So there's a multiplicity of reasons why you get that, run around in the doctor's office, if you will.
Have you ever practiced as a resident or otherwise at what they call a teaching hospital?
Yes.
And what teaching hospital was that?
In my training, my residency training, I spent in internal medicine. You have three what I call postgraduate years, postgraduate year 1, 2, and 3. My PGY 1 and 2 were at the Boston Veterans Administration Medical Center in Boston. I then worked emergency room for a while. I finished my internal medicine specialty training at my PGY 3 was at St. Vincent Hospital in Indianapolis. After that, I was on teaching staff at St. Vincent for a number of years when I was practicing in the Indianapolis area.
Okay. Let me ask you this. What is a nurse?
That's a good question, and I'll give you a slightly laborious answer. The term nursing generally conveys caring for, nourishing, helping another person, and that can take on many different meanings. Formally, when you have nurses in medicine, your hierarchy goes all the way from advanced practice nurse, nurse practitioner, to a registered nurse. RNs, for example, those are the nurses I worked with, my co-directed intensive care unit. Okay, they're very high skill level. Below that is licensed practical nurses. LPNs, a lot of times, are the ones who are on charge in nursing homes and so forth. Below that, you're out of the realm of quote unquote nurses, but you have medical assistants, both certified medical assistants as well as non-certified medical assistants, who do nursing. They take care of patients. In most private medical practice, my own certainly, I have medical assistants because you train them. They have the skill level to take care of the patients. You're not running ventilators. You're not running, IV drips of cardiac medications. You're not doing pacemakers. You're not doing the type of skilled ICU stuff that registered nurses do in hospitals. You're not doing the next level of stuff. You have licensed practical nurses. And quite honestly, you can't.
Wrong. All he said was just wrong. Wrong from the beginning, wrong till the end. They are miracles. They are angels. They are heroes. That's what nurses are.
And pay for that in a private medical practice. So you have medical assistants. Colloquially, a lot of times when people refer to the nurse will be with you, they refer to any of the above, but usually the person that's quote unquote nursing you or taking care of you.
Are you aware of the existence in various states of nursing protection acts or those sorts of things that prevent people who are not nurses to refer to themselves as nurses?
don't really know about that.
Okay. Is there a difference between simply a nurse, as you referred to it, and a registered nurse, for example?
Absolutely. A registered nurse has usually 4-year educational degree, such as you got a Purdue School of Nursing, St. Mary's School of Nursing. It's the highest level of nursing care short of advanced practice nurses, which really are not quote unquote nursing per se, but are providers more on a level with physicians and osteopathic physicians.
Okay.
You're an angel.
Let's get to the question of diagnosis. Now, you said you do practice, of course, in the present day. Are there diagnostic codes that you typically have to use when you do electronic medical records?
The term typically would be a qualifier. Yeah, what we do now is called ICD-10, International Classification of Diseases. So internationally, they've classified literally every disease, and usually there are 5 or even 6-digit numbers. For electronic, to put a diagnosis into the electronic health record, it has to conform to one of those ICDs because you have to punch it in by diagnosis and then by number. So the answer is, unfortunately, I'm well aware of it.
Now, let me give you an example. Suppose I'm a kid growing up, I'm coughing and I'm sneezing, and my mom says, "Paul, you've got a cold." Is that a diagnosis?
As much as a mom can make the diagnosis, as a physician, I don't consider a diagnosis until I've gotten all the information and then I've made my diagnosis. But you could say that it is certainly. Now, whether that's a bronchitis, a sinobronchitis, an allergic rhinitis, et cetera, you can get a little bit more sophisticated. But most of the time, mom's right.
Now, is there a diagnostic code for the common cold?
I don't know. There probably is. The common cold usually refers to adenovirus. There's a whole spectrum of viral illnesses. We all know about COVID. We all know about influenza A, influenza B. And the reason we know about those is because we have specific treatments for those. And there's a whole bunch of other quote unquote viral syndromes. There is a ICD-10 diagnosis for upper respiratory tract infection, upper respiratory tract virus. If you want to be really specific, and you can send DNA testing of somebody's sputum, and they can tell you if it's adenovirus, rhinovirus, rotavirus. None of that makes any difference clinically. You still take coldies, chicken noodle soup, and watch Netflix, and probably you're better off not spending the $600 for the polymerase chain reaction to tell you which common cold virus you have. But there is a code for each of those.
Now, I believe during the deposition, I had slipped and fallen my driveway, and I mentioned about having some pain in my forearm. And I think there may have been a reference in some documents concerning this case of someone reporting having upper arm pain or something like that. Now, was there a diagnostic code for upper arm pain or something of that sort?
There probably is. Okay. I don't know what it is for sure. But now you get into some of there is literally a international classification of disease code if you put modifiers on for, I can't remember the injury, I think a burn while water skiing and something else.
And that's actually diagnostic code.
That's actually there, yeah, if you use the right modifiers. And that was cited a few years ago when we were going back and forth about whether or not we should adopt ICD-10. There was a line of thought, and I subscribe to this, that sometimes you can get a little ridiculous with these diagnoses. So I've never had anybody on fire while water skiing and injured, but maybe I just
it could happen.
Enough experience.
Now, let me ask you this. When someone is roomed and then they first meet with a medical assistant, does the medical assistant typically get what is it called, a major complaint? Is that what it's called?
Chief complaint. Yes.
Chief complaint. I knew it was something like that. Now, is the rendition of the chief complaint from the patient to the medical assistant and the medical assistant writing that down or digitally entering it on the electronic health record, is that a diagnosis in the literal sense as opposed to the government paperwork sense?
I do not consider it such. And the way it works, you go to the doctor, you tell them why you're there, okay? And that's the chief complaint. I'm having chest pain. And then it's the practitioner's perspective to Subjective. Take a history. Do a physical examination. What's the objective part? Then you make an assessment. The formal assessment is the diagnosis. Okay. And then after that, you come up with a treatment plan.
Okay. Now, the determination of treatment plans, is that a decision for the provider, whether nurse practitioner or medical doctor, to make?
Yes, to me, it's a provider purview.
Okay. And in the process of making that determination of the course of treatment, does the provider typically rely upon information provided by lower classes of medical providers? I shouldn't say that, sounds kind of elitist. Medical assistants, nurses, et cetera?
Sure. As the physician, as the provider, you take all of the information, what the patient tells you, what the medical assistant tells you. You have laboratory data, you have objective data, you have test data, lung function data, oximetry data. And that's all information that then the provider makes your assessment, use your professional judgment, and you make your assessment, quote unquote, diagnosis.
Now, another thing that's provided having to do with the practice of medicine is prescribe. It's defined. Prescribe or prescription means to direct, order, or designate the use of or manner of using a drug, medicine, or treatment by spoken or written words or other means and in accordance with statute. How do you interpret that as far as what doing a prescription is as a medical provider?
Could you repeat that? I've never heard that description before in my life.
Well, it's actually a definition in the Indiana Code, but it says prescribe or prescription means to direct, order, or designate the use of or manner of using a drug, medicine, or treatment by spoken or written words or other means and in accordance with law.
Okay.
So how do you make a prescription in your practice?
That description is, I think, a pretty long-winded, but it includes everything. In the real world, the way
He thinks that's long-winded.
you prescribe medicine, what we used to do is you'd have a prescription pad, and if you have a bladder infection, you write amoxicillin 500 milligrams TID 3 times a day times 7 days. What you do today is everything's in the electronic health record, and you, under the problem that you have, if it's urinary tract infection, there's a little button where you can add on, prescriptions and so forth, and you type in amoxil, the screen populates it, and then you write the dosage, and an algorithm comes up. 250 milligrams, 500 milligrams, 1,000 milligrams. You click on the 500 milligrams, and that says how many times a day, once a day, twice a day, 3 times a day. You click on 3 times a day, and then it says the duration. You click on 7 days, and then that electronically stores it in the computer, and then when you're done, you push a button, and it electronically goes to the pharmacy designated that the patient has listed as their pharmacy.
Now, when I go to see a physician, which thankfully isn't very often, but I'm always asked, okay, do you still go to the CVS pharmacy on Randolph Street, in my case? And then the medical assistant or whoever puts that in there confirms all the information. They ask me, okay, are you still on these medications? And then they make sure that that's all entered. Any new medications you're on, that sort of thing. Is that the sort of thing that a medical assistant could do when they're entering that information into the computer?
Yeah, most all the time, that's the thing the medical assistant does do. Just practically, the physician doesn't have the time to do all that, and that's what you have the medical assistants for. It's called reconciliation of medications. If the patient's seeing you, you're reordering all the medications. You want to make sure that the medication list that you have is current. With too many computers, you've got too many lists, and they fall out of favor very, very quickly. So if they're doing that every time, that's appropriate. It's good that they're taking the time to make sure that they're giving you your current medications.
Okay. And if the dosages have changed or anything like that, then that's entered as well, right?
It should be, yes.
Okay. Now, as long as it's with the either prior or subsequent approval of the provider, is it acceptable in your practice for a medical assistant to simply enter, again, with prior or subsequent approval, a refill of a prescription?
Yeah, absolutely.
Okay. In your experience, did you practice during the time when they still had paper prescription pads?
About 90% of my professional career, yes.
Now, always seemed to me when I saw a prescription pad that the signature always looked the same.
Hi, Tara.
Was it common practice for prescriptions to already have their signature stamps on prescription pads?
Back at the time, absolutely. And if you want to really go back, okay, about 20 years ago, you'd walk in and the doctor's desk and the prescription pad would be right there on the desk. Okay. It was a much more innocent time for all of us, I think.
It sounds a little sketchy nowadays, though, doesn't it?
Nowadays it does, but anyone went to a doctor 20 years ago, that was absolutely standard operating practice, and it wasn't my practice. That's how I learned it. You always had the prescription there so you could tear it off and write it if you needed it.
Now, as long as that's done with the doctor's supervision, is that still acceptable practice even in the electronic age?
Yes. So, I mean, the mechanism's changed. It's not paper, it's electronic, but the procedure of executing a prescription remains the same.
Okay. Now, when it comes to the electronic system, and if I recall from our deposition a month ago, you may have indicated you used a different system than Daniel Tanner in his practice, but under the electronic health record system, is there a way in which you make sure that a prescription is approved by a practitioner as opposed to an employee of the practitioner?
There's a big difference between controlled medications and non-controlled medications. Okay. Is that what you're alluding to?
I'm getting to that point, yes, but that's a good starting point. I was going to get to that. Is there a difference in which legend drugs are treated as opposed to controlled substance in the prescription process?
My understanding is the term legend drug just means a prescription. Okay. And if it's just a prescription, anybody with authority on the computer system can do that. That's very different under the regulations of the state of Indiana versus a controlled medication. And by controlled medication, it goes anywhere from, they have different schedules. Schedule 2 of controlled medicine, things like Percocet, narcotics, Dilaudid, morphine, all the way up to Schedule 4 are nerve medicines, things like Xanax, Valium, etc. Schedule 5, I think, is some nerve medicines like Lyrica for nerve pain, etc. The DEA has all these different schedules, but if it's a scheduled medication, only a practitioner has authority if he has a Indiana State Controlled Substances Registry number and DEA number. Only I can do that. Medical assistants cannot do that.
Now, there's something called two-factor authentication. Is that true?
Not sure what you're referring to.
Well, when you do prescribe controlled substances at times,
yes,
correct? And do you do that electronically?
Yes.
And is there, do you have to first check in order to, or sign or log in order to make the prescription, and then you have to do a second factor of authentication on your cell phone or whatever in order to make sure that the prescription is transmitted?
Yes. Quite literally, this is my glasses case in case anyone wants me to read anything. But if this were my phone, I'm internal medicine. I've specialized in pretty sick patients. My average patient may have 25 active medical problems. They may be on 15, 17 different medications. 15 of those 17 medications are executed by the medical assistant. Have to be, otherwise I'd be doing nothing all day but clicking buttons and setting in medicines. If I write 2 medications that are controlled, then at the end of the day, I take my phone, I press a button, it puts me on an app to the state. And on my phone, a 6-digit number comes up. When I press the button, I have a registration with the state. It clicks on, this is Getzing, this is cell phone, he's internal medicine, here's his DEA number, BG 1476877. And then it recognizes me and it prints out a 6-digit number. There's a little clock that goes around. I have 30 seconds to enter that 6-digit number on the computer. If I do that, that authenticates it and it says, this is me, I'm licensed, I'm sending in a valid prescription. If I don't do that within 30 seconds, if I hit the wrong button, it flashes red, it voids it out and says, try it again, buddy, you messed up.
A previous witness indicated that one time she lost a phone.
Object to that, Judge.
All right, I'll rephrase.
I'll sustain the objection.
In the event that you were to lose your cell phone, would that cause at least a temporary problem in this process as far as using the app and sending in prescriptions for a controlled substance?
The answer is yes, it would. And I don't know what I'd do. I'd go to my practice manager and I'd say, help me.
Okay. Now let's go to the legend drug prescription. And for that matter, let's go even beyond that. Is ibuprofen, therapeutic dosages of ibuprofen, is that a legend drug?
No, ibuprofen, Motrin IB is available over the counter here in the United States. It has been, I think, since I've been in high school, pretty much all of our lives. And so it's in the same over the counter category of aspirin or Tylenol. It is not a legend drug.
Now, is it possible that you can prescribe it over the counter? Like, for example, you can get vitamin D at CVS. Can you prescribe that as well?
Absolutely. And a lot of practitioners, myself included, will, there are two things. There are certain concentrations of over-the-counter drugs, such as ibuprofen 800 milligrams, that I don't think you can buy over the counter. I can prescribe you an 800 milligram tablet of ibuprofen, and that is legend. The other thing that many practitioners, myself included, do is if I'm prescribing you vitamin D, for example, for immune health and for bone health, I will write you a prescription for that. It's not expensive. You can get a year's supply for $14. But a lot of insurance companies will pay for over-the-counter medications. And their idea is the doctor's writing you over the counter. We like that. It's cheaper than something expensive he's going to write. And if it saves my patient $15 a year, I'm happy to put it in. And so a lot of times you do write non-legend drugs. You write prescriptions for them to help the patient.
Oh, how many medical assistants do you have working for you?
I have 3.
Great. Okay. And I can't recall if you answered this already or not. Are any of them actually certified?
I think they all are. Okay. And I apologize for clutching on that. Because certification medical assistants, they'll go to like Ross and they'll get a certification. Particularly in practice like mine, I'm internal medicine. I do a lot of things that they don't train you to do at Ross. And so if I have somebody, whether it's certified or not, I end up training them how to do EKGs, lungs function testing, to do a whole spectrum of things that I do as an internal medicine doctor. So I don't put a lot of premium on whether somebody's certified or not. Best medical assistants I ever had was a high school student, and we were associated with a vocational training program. And just a really smart young lady, and she was one of the best I ever had. And she was that good the year after she graduated from high school with no quote.
What can a medical assistant do under the supervision of a medical doctor?
Pardon me?
What can a medical assistant do under the supervision of a medical doctor?
If it's under my supervision, pretty much whatever I authorize or tell them to do.
Okay. Does that include submitting a subscription or prescription electronically?
Absolutely.
Now, how would you do that? Let's say again for a legend drug, how would you provide the opportunity for one of your employees to submit the prescription if, let's say, you were out of the office?
If you're out of the office, there are 2 ways that would be done. Number one, and today's a good example, I'll call in with my staff and they will have gotten phone calls from patients because I've been out of the office, and they will have taken information from patients, and some of those patients may need prescriptions. So they can call me, give me the information. I can talk to the patient, or if they have sufficient information, I can then authorize, after they've quote unquote staffed the case with me, I can tell them what to do. The second way that's done is if you have quote unquote standing orders. Okay. Example of that would be if I have a patient they come in for a dopamedrol shot every 3 months. It's a standing order. They come in, they get the dopamedrol shot. If I'm seeing it's a shot for women. If I'm seeing a patient, they don't interrupt me because there's a standing order for that. And so a lot of practitioners, I'd say most practitioners, will have standing orders of different types of parameters. And then for other situations, they will staff the case with staff.
Can you set a course of treatment ahead of time with your staff and just say, okay, this person's coming in on this particular date. He has this persistent complaint. Communicate with me when he's there, and this is what I will be prescribing, so that they know. Then they just verify with you, and the prescription can be put in.
Sure. What you've just described is what I refer to as a standing order. this is the problem. We see this so many times, and this is how we manage it.
Can you put conditions on that so that, again, you're having this communication with your medical assistant before the person comes in, and then they know that if there's anything different, like when they're taking a history, does this change, that changed, or whatever, or they're on a new medication, then can they be instructed, okay, if anything's changed, contact me first to verify that that's still the course of treatment or standing order we're going to put in?
Yes, and what you just described is actually a good description. If you have the standing order, then you follow the standing order. If something deviates, it's really not a standing order application. Call the practitioner and staff it with them because something's different. That's not quote unquote the standing order.
Hi,
So let's talk.
Walter.
Can you instruct a medical assistant to fill or refill a prescription over the phone, for example? I know it doesn't happen as often over the phone, but can you instruct a medical assistant, okay, I'm prescribing this, call CVS and have them fill it? Can you do that?
Sure. Yes.
And when it comes to your electronic health record, do you catch up with those immediately and make your entries and approve things at the same time, or does it happen sometimes later in the day or when you're done seeing patients?
You mean when you complete the paperwork?
Right.
Most of the time, if you're busy, most of the time it's later. Okay. For example, right now in my office at my house, I have my computer set up and it's linked in with my office computer system. So when I go home, I will complete charts, sign off charts, and so forth. I think that's very standard procedure of the electronic age.
Okay. Well, I have a daughter-in-law is a nurse and a stepson who is going to be a nurse practitioner, actually. And they keep referring to charting. What is charting?
It's actually a very good question. In reality, especially in my specialty, complex medical illnesses, you have the patient and you're talking with them. And on your electronic health record.
Okay, so the prosecutor went first, and she put a bunch of people up on stand saying that in a doctor's office, medical assistants are not allowed to do all this stuff. They're not allowed to diagnose, treat. They're not allowed to train. They're not allowed to prescribe. They're not allowed to do. It was a list. I can't remember it all now. Now his brother, this guy's brother right here, was a licensed practicing nurse, whatever, and I guess got it taken away somehow. I don't know how. They never say how. So he works at his brother's practice. His brother is also a licensed practicing nurse, so they can write prescriptions and they can do all that stuff. So when the prosecutor put their experts on stand, their experts all said, oh no, medical assistants are, they can't order a prescription for the doctor. They can't do this for the doctor. They can't do that for the doctor. Because he's saying his brother was just working as a medical assistant, not as a nurse. Well, this guy is the defense's expert, and he's saying, yeah, medical assistants can do all of that, any of it. As long as I tell them to, they can do whatever I tell them to do.
You have your problem list. I have one patient, and my personal electronic health record is I have one patient with 75 items in medical problems. So you see that patient, and under each medical problem are their medications. So you go down, and the truth of the matter is you can go through things pretty fast. But if you go through 75 items with one patient, you're not going to be seeing many patients that day. So you talk with the patient, you go through, and invariably there's stuff that you want to change, you want to do on the computer that you're not going to take the time to. So what happens then is afterwards, you go back, and I do this, and this is probably what your family is referring to, and you go home, and the reason it's set up in my office at home is I'll sit down, oftentimes for a couple of hours, 3 hours at night, and modify those records and adapt them to reflect what I decided. Okay. People always say, oh, you want you to do your charting contemporaneously. The problem with that is instead of getting out at 4:30 or 5 o'clock, you'd be getting out at 8 o'clock or 9 o'clock, and you'd be paying for the staff to sit there and watch you pick up the keyboard. So I'd say most practitioners will catch up on their quote unquote charting the way I do and the way your family members do.
Now, the Affordable Care Act, which predates COVID, of course, I remember I had an elderly physician since retired, and he was constantly complaining because he was having to sit there at the keyboard with his arthritic hands. He had this thing, and everything changed once the ACA came in. And it seemed like while he's talking to me, he's having to be distracted by entering all these things. Is that how the practice is now with all the data entries required by ACA?
Unfortunately, yes. And the primary reason there are a couple of reasons why I don't like computerization, but people at a higher pay scale than mine are the ones who made the decision, is I think it inevitably distracts the practitioner from the patient, because you're having to sit there and enter this data. I'm kind of old fashioned. I think the doctor has to sit there and look at you and read your face. And when you're telling me what's going on, I ought to be listening and empathizing and asking you questions. I don't think I ought to be beholden to a little box with bytes of zeros and ones. But that's my editorial comment for the day.
Do you ever get away from Mishawaka? I mean, actually take time off from your practice?
I try to once in a while.
Okay. Other than having to be in court. When you do that, how do you take care of patients that may come into the office? Let's say if you're out of town or out of state for some kind of function, a vacation, whatever.
Whenever I travel, I always bring my laptop. With the internet, you can be on your computer system at the office in literally seconds. And I have my phone. And my staff usually goes in for 3 hours a day. And they answer phones, take phone calls, take messages, etc. And then if I'm traveling, I call in once a day and staff patients and complaints and issues with them.
Okay. Now, do you make both verbal and written or electronically transmitted orders to your staff?
Yes.
Is a verbal order still an order as far as you're concerned?
Absolutely.
And when you have, let's say, an unlicensed medical assistant doing things under your instruction, as far as you're concerned, are you responsible professionally for their conduct?
Absolutely.
And does that make you, as far as you're concerned, a person who's supervising their conduct?
Yeah. I mean, by definition, your staff, if I'm the physician, my staff is acting incident to me. What that means is they're under my authority, they're under my supervision. And so anything they do, it's my responsibility because I'm the doctor. I'm the one making the calls.
You said one of the best medical assistants you ever had was a high school student?
Yes.
Okay. Did you ever, if you recall, have that high school student submit prescriptions under your direction?
Yes, like any medical assistant does.
Okay. And then after the fact, when you were doing the charting or whatever, did you indicate that that was authorized in the medical record?
If I ordered it, what I indicate is that I made the order. Who executes the order is irrelevant. So like if you look at my chart, same thing. If it's urinary tract infection, amoxicillin 500 milligrams 3 times a day times 7 days, that's my order. I don't specify who sent it in because it's my order. I'm the one who's responsible.
Okay. So you're giving the order. The assistant is simply the mechanism by which that order is obeyed or executed?
Yes.
Okay. Now, suppose you were to have one of your assistants meet with an individual at your office and you're in communication with that person or at the keyboard, whatever, and you either have a previously determined course of treatment where, if the person comes in, this is prescribed, or during the time that you're communicating with each other, you indicate to that person, okay, this is what they can prescribe. Can electronic prescriptions be submitted contemporaneously with or within a few minutes of an appointment?
No, absolutely. That's one of the advantages of the electronic health record. And I think you've got the idea that I'm not a big fan of it. But one of the real good things is when you have all the medicines set, I walk out. When the medical assistant closes the chart, she clicks a button and every non-controlled medication, it's gone. And in less than a second, it's at the pharmacy. It's on their computer system to be filled.
And the prescription, the printout of the prescription at the CVS or whatever pharmacy, would that indicate your name, Alex Katsimos, and the MD or whatever, and then also have your DEA number, address, all that sort of thing on the label?
Yes, should.
Okay. And that would be regardless of who put it in because it was done under your authorization and direction?
Exactly.
Okay.
Ma'am, did you know that David
Okay.
Tanner did not?
Hold on. We have to pause here. Now that he's done. Whew. Okay. We're almost at the end of the trial. All right, I'm not muted. We're almost at the end of the trial. What's about to happen is almost going to happen. This is another nurse. And I think she works in the office with them. I think. Oh wait, Ginny, it's not over. It has just begun. We just have to get through this last nurse, and she's real quick. And then we get to the magic.
Not have a license.
Objection scope.
You're going to be very happy that you sat through this. You really will.
Your response?
I think it's cross-examination. I think it, as far as her knowledge about things, as far as people in the office goes.
Still has to be within the scope, Your Honor.
Overrule the objection. She can answer.
Did you know David did not have a license?
Yes.
Was David employed by the office?
No, he only came in when we needed him to come in to help.
Okay, so he did not technically work there. He volunteered time.
I don't know the logistics of the monetary anything. I don't know if he got paid. I don't know. He came in and he helped us out.
Okay, but he was regularly there every Wednesday and Friday.
Generally, yes.
I believe you testified that you never identified yourself as a nurse.
No, I never have. I've been called a nurse plenty of times.
Well, and you did not
But-
identify yourself as a nurse because you're not a nurse.
No, I'm not.
You've also corrected people.
I have a nurse outfit.
You said something about your mom that,
Oh, yes.
what was that?
She always told people I was a nurse when I told her, Mom, I'm a medical assistant.
Okay.
It didn't matter. Everybody she knew always called me a nurse.
Well, but you corrected them.
Yes, and then after a while, I just let it go.
On Wednesdays and Fridays, when Dan was in the Rochester office, you were always there with him, or sometimes you'd be in Plymouth, or what?
Not always.
Who would be in the Plymouth office on Wednesdays and Fridays with David?
I would be, the receptionist would be, or
I would have called you a nurse. Easy. I would have called you a nurse.
one of the other office staff would be.
Okay, no other advanced practice nurse, because Daniel was the only one at that time, right?
Correct, but we generally didn't schedule people to come in on those days. Just the people that needed blood draws. Sometimes their diabetes medications, injections. Someone would need a quick blood pressure check. It was like, well, I've got a headache, come in for, let's check your blood pressure. Little things like that that even I could do, in the clinic.
But patients did get scheduled on those days. Yes.
Sometimes.
I believe I have nothing further. Thank you.
Redirect, Mr. Stink.
Christine, let's see. As opposed to March 4th of 20. Before we
I tried to cut out every time they walked away from the microphone. I missed some.
She's asked to strike. I'm going to strike that from the record. Could you approach as well?
It's okay. Everybody's okay. Relax.
Mr. Sanko, we have 2 juror questions that need to be addressed. Would you prefer your client be here for these questions?
I don't see any need for this, for that.
Here we go, guys.
We also have the state here by the respective attorneys, and it is 4:57 p.m. Jury is deliberating. They sent 2 questions written to my bailiff. The first being, what do we do if we can't all agree? First question. Second, and more problematic for the court, is rather lengthy. One of the jurors shared that he had looked up the maximum penalty for a level 5 felony is 10 years. This is starting to affect how other jurors are thinking and how we may change our decision. What is your recommendation on how to proceed knowing this information? So, my position, well, Ms. Typin, I suppose I will turn to the parties to see if you have any suggestion or there's some agreement as to resolve this question.
That's a problem. And I defer to the court's judgment on that because I don't know how that is correctable at this point.
Your Honor, that's juror misconduct.
Yes.
I don't think there's any alternative except the mistrial.
To be fair, I read the question as to that it was not in the deliberations that they looked up the level 5 felony penalty, that it was previously, and then now he's sharing. I'm not saying that's a huge difference, but I'm just simply pointing out the jurors have been in the jury room, sequestered, access to nothing other than the evidence and the instructions. And so I'm indicating that has been intact. There has been no independent research that they've been able to do while they've been deliberating. So it had to have come prior information.
It's still a problem though, because it violates the rules that were prescribed for them initially, correct? Isn't that in the preliminary instructions of the court?
The preliminary instructions covered that they were not to do independent investigation. I don't know whether this information came, whether they did the searching after the preliminary instruction or before, but again, maybe that's immaterial.
In terms of, let's see, final instruction number 11, instructions don't contain any information concerning a possible sentence. Court alone is responsible for sentencing. And they clearly, not only do they finally know, although the information may be inaccurate,
Correct.
about a range of penalties, they also are indicating, according to that question, it's affecting their deliberations. And that's a real problem.
Perhaps, I don't know if the court wants to bring the jury in and poll them individually as to the impact that if they can make a determination without, I don't think that this is reversible.
Curable.
Curable, reversible.
I'm concerned about pulling them individually for a couple reasons. First is it's going to draw direct attention to the person that actually has revealed this information, which the question does not reveal that, other than I know it is not the juror that wrote the question because of the way it's written. But my only thought is to reread the final instructions, because if I isolate one of them, that's going to draw that into much stronger consideration. But you indicated that you thought it was mistrial, Mr. Stanko. Ms. Typen, you were some reference to it being non-curable. I suppose that is what you're insinuating at.
That is what I meant, Judge, yes.
My feeling on that, Your Honor, is it is non-curable because
the foreman told the judge this, the jury foreman.
not only for, and this isn't even the main reason about the fact that if they set a sentence up to 10 years, that's not even true.
Right. I understand the information is not accurate, but I also think that is completely immaterial to the problem of the question.
Right.
Because they are discussing other things than what was presented here in court, which I understand sometimes that happens in trials, but not so blatantly as to the range of penalty for the charged offense.
No.
Whether it be correct or incorrect.
It doesn't change it. And of course, with respect to the mistrial, it would obviously not be due to any type of prosecutorial or defense misconduct. It would be juror misconduct, and the case could be retried. So that's not an issue. Obviously not one I'd raise because it's not appropriate to raise the issue that my client could not be retried. He clearly could be under these circumstances.
I'm a firm believer in some space between stimulus and response. So give me just a moment here to think. I'm also going to ask that you secure your client because whatever happens next is going to be very operative. So
I'll text him right now to approach the door, and I think Lori can let him in then.
Well, I'll have,
or someone.
I'll have court administrator or security, whoever wants to do that. But I prefer to keep the bailiff here. We'll be off the record for now.
They probably do.
Let them know that I am securing. We're back on the record in 50D03-2306-F532. State of Indiana v. David Tanner. Mr. Tanner's now rejoined us. Mr. Tanner, I trust that Mr. Stanko has advised you of the nature of the situation currently. Yes.
I don't know. What are they called?
I am in the position that I didn't think I'd have to be in. But I think the only choice at this juncture is to grant the mistrial and discharge the jury because my finding essentially would be that
that wasn't the bombshell that it's a mistrial. That was pretty bad, but something he does sound like Aaron. Something else happens.
There's uncurable, as the state puts, or irreparable harm that could occur to the defendant, specifically that the appearance of the juror neutrality has been compromised, at least for that one juror, and then now it is spread to the remainder of the jurors. Yes, Ms. Typen.
Judge, I move that the court hold that juror in contempt because I think that juror directly violated the court's orders and has now resulted in this case in a mistrial, which is very harmful to the state.
Wait till you hear what she wants from the juror. She wants him held in contempt, or her. I think it's a him. She wants him held in contempt, and she wants more. Contempt isn't enough. She wants more.
Defense and the court.
I will address that in a moment once we have the jurors back with us. So I appreciate the motion. I'll address that when I can. To be quite pointed, Mr. Stanko, you made the earlier statement that you believe this resulted in mistrial and that it was no fault of the state nor the court. And so therefore, you didn't think that there was any issue with trying this case again. And I just want you to confirm that that is in fact your opinion now, in the sense that we're going to be moving forward and the state may want to retry this case. Certainly, my decision to declare mistrial is subject to appellate review. And so If you have any record you'd like to make now, please do so.
Well, Your Honor, very clearly, because this was not as a result of prosecutorial misconduct, it very clearly is a case that would not preclude under the double jeopardy rules to retrial my client. I indicated that previously off the record, and that is very clearly the law.
I agree with you that that is the state of the law, but I also wanted to allow you to say that because I recognize that these are delicate and nuanced situations.
Your Honor, I also advise my client of that fact, so he is quite aware of the law in that respect.
Any other matters that need to be addressed before I call the jury in?
No, Your Honor.
Bailiff,
Can you please just come to every stream because we got questions. We always have questions, and you know what we do when we have questions? We just make up answers, and then we think we're right. It would be nice to have another one here. Peg Leg comes in. He's an attorney, so we pelt him with questions. But now you're here. We can get you too.
secure the jurors. Have a seat, folks. Welcome back, ladies and gentlemen. It's 5:19 p.m. and we are in the middle of deliberations for this trial. And to give you an idea, ladies and gentlemen, of what was occurring while the question was delivered to my bailiff, and then now you've been brought into court. I reviewed the question. There were two questions total. The operative question that I'll address is the question about the one juror addressing the range of penalties with the remainder of the jurors. Based on there being discussion about inappropriate matters that should not be before the jury, I have declared a mistrial in this case. What that means is that you will not be rendering a verdict. You will be discharged from your duty. I want to read to you a portion of the preliminary instruction where it says you must not use computer, laptops, cellular telephones, or other electronic communication devices or any other method to, and then a whole host of matters that you are prohibited from doing. And the final paragraph of that is the reason for these restrictions is to ensure that your decision is based only on the evidence presented during the trial and the court's instructions on the law. The range of penalty is not one of those things that you heard in court. So it is inappropriate for you to be addressing those. Could the foreperson please rise?
Snitches get stitches.
Well, it was your question, so to speak. I know you are not the individual that was raising the range of penalty. I need you to let me know who the juror was that identified the range of penalty for the level 5 felony. I understand, ma'am. I will address it with them individually, but juror number 9. Okay, thank you. You can have a seat, ma'am. As I indicated, I'll be discharging you from your duty. What that means is you'll be free to go. You will not be subject to being recalled in this particular case because you served as jurors in this case. But you will go back into the pool and then you'll be eligible to be reserving later on this year. If you have questions, you're free to stick around in the jury room. Juror number 9, I need you to stay in the courtroom here, and we have some final matters to address. I thank you for your service, regardless of the fact that I have declared a mistrial. I want you to understand that your service here today, the day before, and the day before that is very important to the court. Obviously, our United States Constitution is designed in this fashion so that impartial members, the public, can come in, review cases such as this, and make a decision about the facts and the law. I do appreciate that. I know you will not have the satisfaction, so to speak, of making a decision, but understand that I do appreciate your attention. It was uniformly agreed upon that your questions were outstanding. You were very attentive in that fashion, so I do appreciate that.
They say that to all the juries.
With that, you're free to go into the jury room with my bailiff. She'll get you reunited with your phones. As I mentioned, I discharge you of your duty. Thank you. Everyone, please rise.
And that's what she wants. That's exactly what she wants. JK, you always know the ending before it gets there.
Can I have a seat, folks? Juror number 9, can you raise your right hand? Do you swear or affirm under the pains and penalties of perjury to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your full name. And Mr. Reese, during court today that you brought up the range of penalties in the courtroom. Do you essentially agree that that's what happened?
Yes. I guess fine.
Just so you know, we can't hear him because he's not near any microphone. I thought I cut it all out. There, I'm working on it. See? Just give me a second.
When was that?
We only hear one side of this conversation because I can't hear the other guy, but I wanted to keep the judge in. So sorry. It's the best I could do.
When was that? After you were seated as a juror? Right, at the end of the first day. And I will go over that full part of what I read. And I specifically remember that reading this before the break in the day. During the trial, there will be periods of time when you will be allowed to separate, such as for recesses, lunch periods, and overnight. At those times, you must not use those various devices to investigate, conduct research, or otherwise gather information regarding the case.
I don't know who she is.
I think that is evident.
Upset.
Their surprise or their shock saying you can't do that is evidence of the fact that you should not have done that.
Exactly.
I mean, that they're essentially proving the point that I'm trying to make to you. And I respect the idea that there are occasional times in deliberations where other things other than the evidence are discussed, whether that be juror children, what they have going on in the day, the weather, etc. But explain to me how it would be appropriate to then relay that information to the rest of the.
It's specifically in the jury instructions, which I did not put in here because I love you all and I would never do that to you. You may not research the penalties of this. The penalties is for the judge to decide.
Jurors during the deliberations, when from what I can tell, it was near gridlocked. Help me understand now how you appreciate the wrongness or the inappropriateness of your actions.
No, I think he gives them those instructions every single break, every single day, any break, even a 5 minute break.
You anticipated what I was going to ask next, in the sense that there is a specific instruction, the final instructions, that says you are to not consider the range of penalties. The law has been so written so that you can make your decision without that burden or weight. And did that not sink in? Did you not hear that? Doing the independent research was enough for a mistrial or not? Right before you went for deliberations, I told you and all the other jurors, you are to not consider the range of penalty. Part of me calling you here and asking these questions is not just out of my idle curiosity, and it's certainly not to place you in a position of feeling any worse about the decision. But the state has specifically asked for you to be held in contempt because of the violation. And so that is why I am trying to determine how this occurred, the nature of it, et cetera. Ms. Typen, do you have questions of the juror?
Yes, I do. I believe I'm understanding you that other jurors were talking about this being a probationary offense, and you interjected that this was not a probationary offense. The defendant could be looking at 10 years in jail. You understand that 10 years in jail is not the appropriate term of punishment for this level of felony. Okay, so what did you say? That you felt the need to correct a probationary punishment as not being significant enough, that he would be looking at something more significant. What is the correct term of sentence? Okay, well, that's basically what I said, and you just denied that. So, okay. The point is trying to talk others into thinking that it was more significant than what they thought it was, and trying to influence their decision because they were wrong about what their understanding of. But you felt the need to interject and correct it because they were wrong in your mind.
Yeah, misguided by him.
That's right. But you didn't pay attention to that because
You mad, bruh?
I'm not going to ask for Hubie.
Hold on, Ms. Typen, Mr. Stanko.
Your Honor, contempt is a judicial prerogative. I would choose not to offer any comment on that.
Understood. What were you
Good
going to
lawyer.
say, Ms. Typen?
Good lawyer.
I would ask that if the court is going to order a contempt for this juror, that he be ordered to pay the cost of this jury proceeding, meaning postage, the per diems, the cost of everything. I believe his indication is that he was definitely trying to influence the jury because he felt they were wrong about what they were saying. He was trying to make it clear that penalty should be great, that penalty was greater than what it was, and he was inaccurate as well.
I appreciate the motion and the request. I think him answering the questions as he's done has shown some conciliatory behavior. I'll be frank, Mr. Reese, not as much as I would like, but, and now's not the time to interrupt, but I'm not going to grant their motion for a contempt citation. So formally denied. Appreciate the motion. I understand these things occur, and I understand you were not the only individual speaking about the range of penalty. But I do hope you think and remember back to the moment of just blurting out something, thinking it's appropriate, and then seeing the impact and seeing the spread, because it's range of penalty here, and it's going to be something else in your life next. And so I hope you think about what occurred here over the last 3 days and how that decision,
He won't.
or lack of thought, has impacted everyone here today, all the other jurors, etc. You're free to go, sir. Thank you. In terms,
I think he did not get contempt because the jury was gridlocked. So they weren't going to come to a decision. I think the judge knew that, and I think that's what saved him. I don't know, but because I've seen this judge do bad things to people. That guy is out of there. He probably won't even drive down that street for a whole year. Oh. So if you missed the beginning, don't watch the beginning. That was just for my nurses. That was just for the Viber nurses. I thought they would enjoy all of the medical talk. But you didn't miss anything at the beginning. Nothing crazy happened. They were just talking about nurses and medical assistants and stuff like that. But man, he got this close. A juror got this close to being hauled off to jail. Oh man. You don't see that every day, do you? All right. Well, there was a lot of medical talk going on in chat, so how could it not have been medical talk? I was riveted. I loved every second of it. I didn't even know the end was going to happen. I liked the beginning. I liked the medical talk, so I recorded it. Give me a few minutes, and I will have OJ trial up. Just give me a few minutes, and I'll have OJ up. All right? I want to go do something quick. Thank you so much for coming out, guys. I really, really appreciate it. Thank you all who made it to the live. Yes, that would be yesterday now. I'm wearing the same shirt I was wearing yesterday, which really was only a couple hours ago. I appreciate you coming out. I really do. I hope you have a great day. It's the weekend for a lot of you soon, so have a good weekend, and I will talk to you again really, really soon. Bye, guys. Thank you.
Electric light. light. Even when my world turns gray, with a giggle, she lights the way. Kathy's love.